Miss Nag-Abegonia.
Present po. Present po, attorney.
Mr. Gutierrez.
Present po tayo.
Mr. Moral.
Present po tayo.
Mr. Macalinaw.
Present po tayo.
Hold on, class. Okay, let's continue. Mr. De La Cruz.
Present po tayo.
Mr. Miravite.
Present po tayo. Good evening po.
Okay, good evening. Miss Tambago.
Malilate daw po, attorney.
Okay. Mr. Betualio.
Present po tayo.
Mr. Alpe.
Malilate daw po, attorney.
Miss Paning Bata. Miss Tolentino.
Present po, attorney.
Miss Soledad is here. Mr. Bahal, are you here?
Present attorney, good evening po.
Mr. Ivy. Wala. Miss Tambago. Wala pa. Miss Rio Florido. Wala pa. Mr. Fadriqueta, are you here na?
Present po tayo.
Miss Forne Darapisa.
Present po, attorney. Kaya lang po, hindi po ako makapag-welcome kasi medyo madilim po. Nasa biyahe pa po kasi ako.
Okay, but if I call you, please answer na lang. Or how will you manage to do that? Siguro
Sige po,
later.
I'll open my cam pero hindi ko po sure kung makikita po ako, attorney.
Okay. Miss Rio Florido, right here na?
Rio Florida, present po, attorney.
Okay, hindi turn on your video na lang. So we're just waiting for Mr. Alpe and Miss Tambago. Okay, let's start para tayo makauwi. Wait lang, class. Okay, let's start. Sorry class, naipit talaga ako sa meeting today. Kaya hindi ako nakakapunta. But I would like to attend sana. Okay, so since online class tayo, remember, 2 hands, pray, and then close your eyes, pray to the Lord that you can answer my questions to the best of your knowledge and ability for tonight. Sorry, I'll meet you next week. Kapag maaga na, hopefully kami matapos. Okay. Start with Miss Albino.
Good evening po, attorney.
Where are you? Okay. Wait, I'll
I'm
pin.
here po.
Oh.
I cannot recall everything po, attorney.
Yeah, but it's about the corporate name. The change of corporate name.
Yes po.
Okay.
Yes.
So, in the case of Bantogon, the respondent argued that the change of corporate name and the subsequent asset sale created a distinct legal identity. So, do you remember that part?
Yes po.
Okay, so how would you reconcile that with the doctrine of the doctrine about the identity of a corporation? Does it follow the change of name of a corporation?
No po, attorney. The court ruled po that once the corporation change its name, it doesn't mean that the corporation changes in relation to the rights, to the properties, and the existing obligations of the corporation po. It means that the corporation changes in name is still the same po. It's just that it operates under a different name, attorney.
So how did the Supreme Court rule? Is the newly changed corporations still liable for the payment of the
Yes po,
second?
attorney. Yes po, attorney. The corporation with a new name is still liable po with the liabilities of the previous corporation because because the changes in the name of the corporation doesn't mean that it changes all the liabilities, properties, and rights po of the existing.
Okay, so how do you change a corporate name?
Through amendments, attorney.
What would be amended?
Through the amendments po of the Articles of Incorporation.
And where are you going to submit the amendment?
To the Securities and Exchange Commission po.
Do you remember how many votes are required for the amendment of the corporate for the amendment in the AOI reflecting the change of corporate name?
Majority of the votes po of the outstanding capital stock and 2/3 po of the stockholders or members.
Actually, it's okay. That's okay, Miss Albino. But it's actually baliktad. It's supposed to be majority of the board of directors and 2/3 vote of the stockholders. But it's okay. Class, ito lang yung tip doon. Usually, it's always majority of the board of directors and 2/3 vote of the stockholders. So, example, hindi nyo talaga alam kung ano yung voting requirement. Pag hindi nyo talaga alam yung voting requirement at maghuhula kayo ng voting requirement, ang default na ipanghula nyo, yung 2/3 vote, yung majority ng board and then 2/3 ng stockholders. But throughout this semester, you'll see kung alin yung mga certain changes na baliktad yung na iba yung voting requirement. So, madadaanan naman natin sila lahat. But by default, hindi naman applicable to all, but usually it's majority sa board and then 2/3 sa stockholders. Mas marami yung usually sa stockholders. Okay, thank you, Ms. Albino.
Thank you po. Thank you, attorney.
Next. Miss Orne Darapiza. Oh no. Sige, babalikan
Yes
kita.
po. Ayan po, kita na po asapan.
Yeah, pero are you still on your way?
Opo. Pero I think kaya naman po yata ng data.
Okay, sige. Sige, let's start. Questions. Wait. Student number 2. Okay. Do you remember the doctrine of secondary meaning?
The doctrine of secondary names means that words, for example, generic words or geographical words that originally cannot be exclusively appropriated may, by long use, be so associated with a specific entity that it acquires the secondary meaning.
Mm-hmm. How was that related to the case of Lyceum?
In the case of Lyceum, if I remember correctly, the Lyceum, they filed a petition so that they can have the exclusive use of the word Lyceum. However, the ruling is that the word Lyceum is not generic because it means a school or institution of learning, and it has been used way before the Lyceum of the Philippines registered its name. Therefore, the Lyceum of the Philippines was not able to acquire exclusive use of the word Lyceum.
Okay, do you still remember? Okay, go ahead. Sige.
And the word Lyceum did not acquire secondary meaning.
Okay, so that's for the secondary meaning. Do you still remember what the claimant must prove in order to claim that they actually obtain secondary meaning of their name? Their corporate name?
They must prove that such word is not generic, or it must be suggestive, that when a person hears that word, it will be associated with that specific entity.
Okay, sige. Thank you, Miss Orne, the representative. Okay, so just for
Thank
the
you po.
benefit of the class, it was also discussed in the case that there must be the substantial exclusive use for a considerable period of time, that the business has acquired a goodwill, and the public identifies the term uniquely with the claimant. So those three concepts must be proven in order to prove that there is a secondary meaning in favor of the petitioner or the claimant. Next, Mr. De La Cruz.
Attorney.
Earlier? Okay.
Yes po, yes po.
Wait. Okay, but do you still remember the case of SEC versus Omico? The case about proxy?
Can
The
open up
validation
about
about the regulatory authority.
of the SEC po, tapos po yung sa RTC po po yung attorney.
Yes, okay. Discuss the ruling of the Supreme Court in that case.
If I remember correctly, attorney, the Supreme Court held that the SEC has supervisory jurisdiction over corporate conflicts po, attorney. So, however, the Supreme Court also ruled that there must be no fragmented jurisdiction over the RTC and the SEC, wherein in this case, the SEC is the one who were deciding the issues on the case. However, the RTC was the one who were executing the decision. Kasi, I remember correctly.
Okay, so in that case, who has jurisdiction? SEC or RTC?
I can do it.
In the case, attorney, the jurisdiction was vested before the RTC po.
Why?
Because attorney, if the jurisdiction was vested on both courts, there is an occurrence of fragmented jurisdiction because there will be, because the Supreme Court held that the RTC has exclusive jurisdiction over the case, because they have the power to adjudicate it, they have the power to try. They have the power to hear, try, decide, and execute its implementation and orders.
Yeah, but I remember they discussed about the jurisdiction with regard to proxy, for concerns involving proxy. So, how did the Supreme Court rule which one has jurisdiction between SEC and RTC when it comes to matters involving proxy?
In matters involving proxy, attorney, SEC has jurisdiction for attorney.
All the time?
If the proxy is within the if the issue that was being involved, attorney, was an intracompany dispute po, then SEC has jurisdiction over it, attorney.
No, that's a different case. I'm asking about the proxy. Proxy means proxy is used whenever there's voting involved in a corporation. So we'll discuss later on what's proxy, probably chapter 4, chapter 5 yata ng book. But my question is, how do you determine if the proxy matter should be referred to in RTC or SEC? Do you still remember or not na?
If I'm very honest, attorney, that part po hindi na po.
Okay, sige. That will do, Mr. De La Cruz. Thank you.
Okay po.
Next. Mr. Bitwalia.
Attorney,
Hello, where are you? Wait, I'll just pin you in my... Okay, we go to the next case. The AZ Realty. This is about the deceased person. Yung deads na siya for how many years? 7 years yata yun. And then, the person, si Pasita, I remember her name, Pasita. She was included in as an incorporator in the AOI, right?
Yes, attorney.
Okay, first question. Can you include a deceased person as an incorporator in the AOI?
Attorney, as per the revised corporation code, attorney, you can include the name of the deceased person in the AOI with the consent of the estate, attorney.
With the consent of the estate? Who's the estate?
Those are the heirs, attorney, of that particular stockholder, attorney.
Okay, and is that the general rule? You can always add a deceased person as an incorporator in the AOI?
Actually, attorney, that's an exception to the rule, attorney. But the general rule is that you cannot include a deceased person in an AOI because the capacity or the juridical capacity of that person is utile, attorney. So, meaning that you can only add a natural person who is still alive po.
Okay, that's actually right. So, in this case, it was discussed as to whether or not it is fraudulent is it fraudulent to include a name of a deceased person as an incorporator, right?
Yes, attorney.
Okay, so how did the Supreme Court rule? Is there fraud?
Attorney, there is no fraud as to the way it was written in the AOI, attorney. But the Supreme Court reiterated that the name of a deceased person cannot be included in a general consideration, cannot be included in the AOI.
Mm-hmm. And if there is no fraud, was the SEC right in demanding the revocation of their incorporation?
Yes, attorney, because there's an infirmity in their articles of incorporation, attorney, provided that they have included the name of a deceased person, attorney.
Okay, so there's fraud. So does that mean, are you saying that the Supreme Court said that SEC was right to require the revocation of the incorporation for this corporation?
Yes, attorney.
Alright, sige. That will do, Mr. Vitualia. Sorry, thank you.
Thank you.
Next. Plus, I would just like to correct that part. The Supreme Court in this case did not require them to revoke the incorporation of that corporation. They actually said that SEC should have given the corporation more time to correct the changes if necessary, not to immediately demand the revocation, since they also did not found anything fraudulent. They did not have any findings that there is fraud committed in this case, because it was also mentioned here that there are two situations where SEC may found a corporation's certificate of registration as fraudulent. First, if the company was incorporated with specific and dominant intention of pursuing a fraudulent business purpose. And number two, misrepresentations to meet the minimum qualification. So I remember in this case, it was discussed that even if we remove the name of Pasita, there are still 6 more na incorporators, and that time the ruling, the minimum number of incorporators is 5. So kahit mawala si Pasita, may 6 pa. And then yung business purpose naman, it was discussed in the case, and it was not found fraudulent. And her inclusion is to preserve her legacy. I also remember it was somewhere there. Okay, next, Miss Paningbatan.
That's Syllabus.
I believe. Okay, next. Let's see. Okay, so case again about about SEC's power to order refund. It was discussed in the case of Subic Bay. Do you remember that one? We're on the part discussing, we're on those cases discussing about the powers of the SEC. Yes. Yeah. Judicial review of committing orders. Do you still remember? Have you reached the case of Subic Bay? Okay, let's move on another case or question. Okay, how about this question? So Section 17 of the Revised Corporation Code provides a new standard for corporate names. The standard is distinguishability. So what's its difference with the previous standard using confusing similarity test?
In terms of distinguishability, an existing corporate name should not be confusingly similar to an existing one, which a person with exercising ordinary care or discrimination can distinguish the name of the other corporation to another one. While the prior test so long as there are no secondary meaning attached to the name of the corporation, it is valid.
Okay. Let's move to the next question. How about the expiration of the term of the corporation? Expiration of the corporate term. Can you discuss to me what you know about the corporate term's expiration?
With regards to the corporate terms expiration, prior on the old civil code, a corporation can exist only with 15 years. However, the revised corporation code, a corporation has a perpetual existence except when the corporation itself provided for its own expiration within their articles of incorporation.
Okay, last question. Can you revive a dead corporation?
Just a thing. They can revive a dead corporation provided that there are you follow documents or as well as certification needed by the set or the approval by the directors or board of trustees of the previous corporation.
Alright, that will do. Thank you, Miss Neymar. Next, Miss Rio Florido.
Attorney,
Oh, yes.
nag-avail po siya.
Okay. Row of Mercy. Okay,
Yes,
just pag may nadaanan akong row of mercy.
Apa.
Kaya natin tapusin to class. Mabilis lang to. Miss Abegonia. Hello?
Good evening po, Attorney.
Yan, you're here. Wait, I just changed the pin. Okay. Wait, dumaan na ba tayo sa SOP Skills Frost here? Hold on. Okay, let's go back to the discussion about one-person corporation. Yeah, wait lang. Here. Wait, bago ko itanong, titingnan ko muna kung nadaanan mo sa review. Here. Wait. Okay, so since we're currently studying the forms of articles of incorporation, section 14, there is, how many incorporators are there for one person corporation?
Only one attorney.
Only one. But, do you still remember if there are also other names required to be written in their articles of incorporation when you are an OPC?
Names.
Just the one person. Just the incorporation.
They can include other name attorney as long as it has consent from that particular person.
Okay. Okay, I will not include that in the grading, but you have, if you're a one-person corporation, you are required to name your successor and your alternate successor. That will, that's required by law in order to make sure that in case the incorporator suddenly died or become incapacitated to perform his obligations in the corporation, there will be automatically another person available or nominated to take over or to be the one to handle or make sure na grave violations, etc. They usually announce it in public, but it's not the general rule. It's the exception. The general rule is it's usually confidential. Okay, let's proceed with purpose found in the AOI, Articles of Incorporation. So what do you still remember about purpose?
With regards to the purpose of the corporation, it is indicated in the Articles of Incorporation. So if ever that the corporation did not follow they violated the purpose for which the corporation was formed, these are called ultra vires acts. They are not technically illegal, however, they are not consistent with that, with why the corporation was formed.
Okay, good to know you know ultra vires act, so we're gonna cover it more when the time comes. But let's proceed with how many purpose is indicated in the AOI?
I believe, attorney, there are no limits with regards to the purpose.
Mm-hmm.
If that's, I remember.
But usually there's primary and there's a secondary.
Primary, secondary.
So, is there an instance where, is there an instance where, for example, non-stock corporations, can they include a purpose that contradicts their nature?
No po, attorney, because those contradicts their nature, meaning they do not follow what the article, what the purpose was. Is that the reason why the non-stock corporation was established? Therefore, it is not allowed po, attorney.
It's actually allowed. Check the RCC na lang later. And then, last question. This is, dalawa kasi itong question to. So, last two questions. One is, can SEC reject your purpose? Or, reject or disapprove the creation of the corporation due to its purpose? And then, number two, why?
Yes po, the SEC can reject the purpose, especially if it is contrary to law, morals, good customs, public order, or public policy.
What's the grounds? When can SEC exercise that right?
When it violates law, or it is not.
Okay.
Is contrary to law.
The purpose is contrary to law. Okay.
Morals, good customs, public order, or public policy.
Okay. Thank you, Mr. Makalinaw. That will do.
Thank you po.
Okay, dami ng mga chill. Marami na ako natawag. Let's go to the next one. Nakalahati ko na ba? Ang dami nyo kasi class. Miss Tolentino.
Yes, Padre.
Let me see. Miko, we're done with that. Okay. Miss Tolentino, do you remember the case of the war? It's not a war. It's a case between UCCP and UCCI. UCCP and Bucci, the religious corporations.
Yes, Padre. Yes, po.
So how did the Supreme rule in this case?
Okay. So, just a glimpse of the facts of the case. So, the PUCCI is affiliated to this. Yes.
Cebuchi ay Cebu. I think it's a chapter na nasa
Yes po.
in Cebu. Whereas
Yes,
you is the national organization, and they are all registered corporations. They are religious in the nature of a religious corporation. So
Yes.
here is who has jurisdiction.
Okay, so the Supreme Court ruled that the SEC still has a jurisdiction regarding the religious entities like this, especially that the BUCCI has still an authority to disaffiliate themselves to that incorporated religious entities, saying that the religious entity still has a power or a jurisdiction regarding the corporation law. Thus, the Supreme Court stated that the ecclesiastical matter is not purely on this case because this is corporated or incorporated as a non-stock corporation. Thus, the corporation law still prevailed.
Okay. Next question. Can you amend everything that is in the AOI?
Amend everything, not Padre. No, Padre.
Okay, let's start first with what can you remember about the details that has to be included in the AOI?
The things that's able to amend po.
First, what are the details that you have to include in your AOI according to the RCC?
Okay, so first there should be a corporation name. Second, there is a purpose clause. Third, there is a principal office. Fourth, there should be the term of existence. 5, the incorporator's name, nationalities, and residences. Number 6, the numbers of the directors and trustees. 7,
Not in the byte, in the AOI. The number of directors. I just want to clarify.
Sorry po. So the numbers of directors. 7, the names of the first directors. 8, the authorized capital stock. 9, the subscribers, and 10, the other matters po.
Okay. How about the par value? Do you have to include it in the AOI?
If par value is already stated po, attorney, but it's optional po.
If the par value is already stated?
If the corporation already stated, then it should be stated on the AOI. However, if it's not, it's optional to be stated po.
Okay, later on we'll discuss further if there are requirements about setting par value. If there's an amount required, etc. But that's for... Okay, next. Asan na yung next ko na? Okay, can you amend all of those?
No po, attorney.
So which ones are the contents that cannot be amended?
First is the name of the incorporators, the names, the nationalities, and their residences. And yeah, that's all po, attorney. The name of the incorporators.
How about the directors?
Um, sorry, yes po, attorney, the names of the acting directors, because eventually there should be another election regarding the directors and trustees. So the names of the first directors can be amended on the AOI po.
Alright, thank you, Ms. Valentino. That will do. Next, we still have 10 more. So, kalahati na natawag ko. Amazing. Next, and it's just 7:30. Mr. Miravite.
Good evening, Doctor.
Okay, let's now proceed with what will happen if you will not use your corporate charter.
What will happen if I will not use my
Corporate chapter. Corporate chapter. Charter, sorry.
corporate charter? If corporate charter is the articles of incorporation, attorney.
Your incorporation per se. I mean, you as
The effect. Attorney, if upon the incorporation, when the SEC has already issued an articles certificate of incorporation, and you fail to use the company within a period of 3 years, the SEC may now tag the company as delinquent company, and therefore it may it is as if abandoned. But later on, the corporation, if decided to use the corporate charter, the company itself, they may file revival with the corporate with the SEC.
okay, just to take note, it's 5 years.
5 years, sorry.
It's within 5 years. And is there a cure period? Cure period, meaning time when the corporation can, after being tagged as delinquent, can they still have time to correct it before their license will be revoked? Or automatically revoked after 5 years?
After 5 years, attorney, it is automatically revoked.
I think there's actually 2 years that they can resume before, as delinquent, before it will be revoked. But can you check and let me know? And then next, about the case of, okay, can a corporation validly provide disqualification details of a stockholder to be stated in their bylaws?
Yes, attorney. But the purpose of the bylaws is to provide for an internal rules, which includes one of the stockholders or the directors may decide to be included in the bylaws is the qualification of the stockholders.
And you can put everything. Example, if I want all the stockholders to be pretty, can I put that?
As long as attorney, it is
All of them.
as long as the standard is valid or is not prohibited by law.
When is it valid?
If it's not contrary to law, morals, customs, and public policy.
Yeah, class, that's the default answer. Okay. If it's not contrary to laws. Okay. How about principal office?
Ano?
Is there a requirement as to the principal office of the corporation?
The requirements of principal office of the corporation must be in the Philippines.
Must be in the Philippines. But how about the stockholders? Do they have to be Filipinos?
It depends, attorney. If the stockholder, if the corporation, the purpose of the corporation prohibits that the foreign entity or foreign individuals be part of the corporation or a shareholder. Yes po, attorney. Foreigner are not allowed po to be incorporated.
Yeah, example, those
Those that are in negative list, such as when the when the purpose, or if it's involved, example, if it's involved public um, for example, real estate attorney. Example, the corporate, even though according to the grandfather rule, even though the corporation, is a separate juridical entity, the corporation may not own land, or will not should not be involved in a real estate company, provided that the stockholders, there's a foreigner in one of the there is a foreign entity in the in its stockholders po.
Okay. Last question about asan na yun? Wait, hold on. About non-stock corporations. What are the other details that must be stated in their AOI?
The details that must be, aside from the name of the corporation, the principal office address.
Your classmates also mention all those that are needed to be included in the AOI. For non-stock corporations, is there something unique with them?
The unique in the articles of incorporation of a non-stock corporation attorney is that instead of the authorized capital stocks, the details that must be indicated in the AOI is the contribution of the founding members, or the donations of the founding members.
That will do. Thank you, Mr. Mirandi. Next, we have Mr. Coral.
Good evening, Attorney.
Mas nauubos na yung questions. Oh my God. Okay, next question. Can the stockholders delegate its power to amend the bylaws to the board of directors? Or okay, sige, let's start with this. What's the voting requirement for the amendment for the amendment of bylaws? It was mentioned.
The amendment of bylaws, Attorney, the two-thirds of the stockholders or members of the corporation, and the majority vote of the board of directors or board of trustees.
The amendment of bylaws is two-thirds, majority plus two-thirds?
The amendment of bylaws, Attorney, is the two-thirds votes of the stockholders on.
Are you sure? Okay, just para mabilis tayo, it's majority. That was also mentioned a while ago by your classmate. So, what do you need to include, or what can be included in the bylaws?
In the bylaws, Attorney, we include one is the proxies for the stockholder or members, then
The stockholders, the members. Okay. We're still in chapter 2, it's part of the syllabus. Go, continue.
the qualification of the directors, officers, or trustees, the corporation.
How about the meetings?
The manner on how the manner on how to conduct a special meeting or I forgot the other term, the attorney, but the manner How to conduct the meeting of the directors, officers, the stockholders, and the members.
And then it also includes, how about the voting for the meetings? Is it required to be put in the bylaws?
Yes, attorney.
Yeah, it's called, what do you call the required minimum number of vote?
The quorum, attorney.
Okay, remember that class, quorum. And then, ano pa ba? The election of directors must also be there, the manner of elections, the penalties, the manner of issuing stock certs, and if ever you allow virtual voting, what are your requirements? You can put that in the bylaws. Okay, and then let's proceed to the next thing. Okay, what is the rule about the use of corporate name of a dissolved corporation?
Once the corporation, attorney, is dissolved, there is a period of 3 years for when the corporate name is protected from the use of the other corporation. Then after that 3-year period, the other corporate may use the name of the dissolved corporation.
Okay, so at all times, you cannot use the name of a dissolved corporation within 3 years?
No, attorney, there is an exception when the use of such corporate name is allowed by the last stockholder representing the dissolved corporation.
Okay, so we talked about, a while ago, we talked about the existence of the corporation. Can you remind me again what's this? What's the corporate term?
The corporate term under the revised corporate code, the corporate shall have perpetual existence unless there is stipulation that there is a certain period for the certain term for the existence of the corporation.
What will happen if, for example, a corporation was incorporated prior to the revised corporation code? The prior corporation code only provides 50, maximum 50 for the corporate term. So what will happen? Are they going to be converted automatically into perpetual?
I'm not sure if it is automatically, but they can be have a perpetual existence as long as they comply with the other requirements required by the reverse corporation.
But can they elect to lessen or shorten the corporate term?
Yes, attorney. The corporate has also an option to extend or shorten their term, provided that said extension shall be for example, 3 years prior to the expiration term of the corporation.
Alright, thank you, Mr. Corral. That's very good. Next. Mr. Gutierrez.
Yes, sir.
We discussed a while ago what are the unique features of an articles of incorporation of a non-stock corporation. So, what compared to an AOI of a non-stock corporation, what is its counterpart for a stock corporation? I mean, those parts.
So, in stock corporation, within its articles of incorporation, it shall include the
the number of authorized capital stocks in the articles of incorporation. It must also include the original subscriber registered. Likewise, the stock corporation shall also include the number of the par value of the
Kuya,
stocks
are you
that
still
they
sick,
are
Kuya?
listed to the public.
Kuya,
And
are you still sick or no more sick?
also,
What?
the total number of shares that is the total number of shares that was divided by the that divides the authorized capital stock.
Do we need to include an arbitration clause in the submissions of a corporation?
No po, attorney. Arbitration clause is not mandatory, but is not a mandatory feature to be included in the articles of incorporation. It's just it's on the discretion of the corporation if they will include this portion in the articles of incorporation.
How about the bylaws?
The bylaws po.
No, sure, Char. Sige, go. How about the bylaws?
No po, attorney, as well. Since the inclusion of arbitrary clause is just a matter of discretion on the part of the corporation.
Okay, let's go to... Can we distinguish what's the difference between an AOI and a bylaws?
So, generally, the articles of incorporation primarily includes the corporate name, it's just it's a general information of what the corporation is all about. It also includes the the principal office, the name of the directors, the incorporators. On the other hand, bylaws provides the procedures for what the company is imposing upon the members of the company. Whereas these bylaws must be strictly followed or must be followed by the members, because as determined by the book under of Chavez, it is the government or the government of the corporation.
Okay. So, for example, let's go back to the question about the arbitration agreement. So, for example, there's an arbitration agreement in the AOI or the bylaws of a corporation, and then there's an intra-corporate dispute, and then the petitioners or the complainants were so irritated to the corporation that they opted to file directly to the RTC their case, the intra-corporate matter. So, is that allowed?
No po, attorney. If there is a arbitration clause prescribed within the articles of incorporation or with the bylaws, it is mandatory for the parties to settle their disputes within the corporation, and they cannot deliver the case before the court directly, because it is mandatory po, because it is a requirement before the court to review the dispute before they entertain the case.
Okay, but if you were the judge, what will you do?
If I were the judge po, attorney, I will dismiss the case and remand the case back to the corporation, because arbitration clause directs the parties to settle their disputes within the administrative supervision of the corporation.
Thank you po. Okay. Miss Nacario. Are you here? Pakigalaw po ang baso.
Good evening po, Attorney.
Okay, nandito ka.
Sorry po.
Nagugulat ako. Okay, let's start the recitation. Wait. Do you remember the qualifications of directors as provided in the code?
Honestly, no, Attorney.
I'll just proceed to my next question. Okay, hold on. Oh, do you remember the SEC opinion about the Puerto Princess, the victims of MV Princess of the Stars? Have you read?
Could you refresh me with the facts just a little?
Okay. Do you remember I included SEC and bank cases in our syllabus? Have you read those?
I read the cases po, Attorney.
How about the SEC rulings there at the last part, SEC issuances? Have you reached that part?
Sorry, Attorney, I don't remember po.
Don't remember or you did not read that part?
I don't remember the facts po of the case, Attorney. But I read the cases po.
It is per se, it's an SEC and bank case. So did you read the three of those?
I don't remember po, Attorney. Sorry po.
Okay, sige. I'll just give you the facts and if you know the ruling, just let me know. If you know the answer, okay, these are the facts. So, there's the MV Princess of the Stars. I think this is the one na lumubog. During our lifetime, I remember this eh. During our lifetime, may isang ship na lumubog. And then, the relatives of the victims wants to requests the SEC to cancel the amendment of their AOI kasi they want the corporation who owns the MV Princess of the Stars wants to change its corporate name. And the relatives of the victims are saying, no, you should cancel that because it might deceive the public and they might evade liability for what happened in the MV to the MV Princess of the Stars. So my question is, first, does SETC have authority to revoke the amendment of the corporate name?
SEC has the authority, Attorney. Especially, it can issue cease and desist order. And when it comes to corporate name, it has the authority to check if there's a confusingly or if it would affect or deceive the public by changing its corporate name.
And next question, if, for example, if SEC will not approve the change of name, if the SEC will approve change of corporate name, the amendment for the change of corporate name, will that extinguish the liability of the previous corporation to the victims?
No, Attorney, because the effect of changing the corporate name is just changing the corporate name itself, it does not distinguish the liability of the corporation. The corporation continues po.
Alright, last question. What's the importance of setting a residence of a corporation?
Sorry po?
What's the importance of, okay, this is a question prior to that. What is the residence of a corporation? How can we determine the residence of a corporation?
A residence of a corporation po, it is what is stated in the articles of incorporation. It is where if for example, there's a case to be filed, it is where the subpoenas are gonna be addressed to attorney.
Okay, so can you
And
file?
when it comes to the po,
Continue.
sorry po?
Continue with what you're saying.
I'm saying po that the residence of the corporation is where, for example, there's going to be a case to be filed in court. It is where the papers are gonna be addressed to po. And yun po.
Okay.
Kuya, close the door.
Where can you file cases against the corporation? Oh, sorry. Where can a corporation file cases?
It can file cases po to the Security and Exchange Commission po.
I mean, the venue.
It is where the corporation is registered po as residence po. As residence.
Okay, so what will happen if Corporation A will sue Corporation B? Where is the proper venue of the case? If they're both corporations, and for example, one's principal residence is in Cavite, and the other one is in Taguig. So Corporation A, Cavite, Corporation B, Taguig. They're both corporations with different address or residence or principal office. So where are we going to file the case? Example, A is suing B.
In that case, attorney, the two corporation can have an agreement as to where the case to be filed, attorney.
Hindi nga sila magkasundo kung, example, magkaaway sila, hindi sila talking terms. Tapos, company A in Cavite wants to file a case against company Taguig. So where does company A needs to file the case in Cavite, where it has its principal office, or in Taguig, where B has its principal office?
It would be on Taguig, attorney, onto the respondent's address.
Alright, thank you, Miss Nakari.
Wait lang, na-aircon kuya. Mahulog ka.
Next. Class, remember,
I told you to go down.
an action against a corporation must be filed in the place of its principal office. An action against. So, principal B. Next. Tayo, Mr. Mahomok, sorry.
Yes, okay.
Mr. Mahomok, are you present during the first day? I mean, the intro meeting?
Yung intro break po. Yes, okay. Last week.
Do the meet and greet face-to-face
Like assignment?
next week. Sayang. May dadagdag pa sa class, middle. Enrollment pa ba? O tapos na?
Tapos na po, attorney.
Good. Okay na yan, 20. Ilan yun? 22 yata kayo. Okay. Questions. Okay, let's discuss about the revival of a corporation. So how can you prove that a corporation is already revived?
I'm so sorry, Padre.
Okay, I'll repeat the question. Di ba kanina we were talking about revival of a dead corporation? So,
Yes.
okay. So, after you apply in the SEC, which was mentioned a while ago, and
Yes.
the SEC approves the revival, as a corporation, how can you show that the application was already approved and you are successfully revived? Parang pasyente na. Basta yan. How can you everybody that you're revived?
Once a corporation sends its application for a revival and then it was subsequently approved, the SEC will issue a certificate that the said company, that the request of the said corporation for revival has been approved.
It's called certificate of revival. And then, what will happen, for example, because we discussed a while ago that some delinquent, some corporations which are in their delinquent status, do you remember the delinquent status a while ago?
Yes, those corporations who started their operation but subsequently for consecutive 5 years has stopped its operation.
And then within 2 years, they still did not operate.
Yes,
Okay.
within 2 years, but they can still file for their money.
Okay, so for example, there are debts, liabilities, or duties that was not carried out before it was declared dead. before its incorporation has been revoked. So what will happen? Is it start of something new when you have your own, when you were issued a certificate of revival?
No, po, attorney. There will be no new debts for if the said corporation po prior its issuance of certificate of revival, all of its prior debts shall be carried once the certificate of revival was issued.
Okay. So, for example, nung in-incorporate ko yung corporation, hindi, huwag na nga ako mag-example, malilito ko pa kayo. But yeah, that's the rule. Question. Okay. Are there instances where sign the bylaws?
Those prior the incorporation po, the bylaws shall be have signatories of all the directors in trust, all of the directors and all of the directors and capital, majority of the capital stocks, the owners of majority, and the majority owner of the capital stocks.
Okay. So, which example, sorry. Alin ang mauuna? Magiging stockholder ka o magiging director ka?
Stockholder po.
Why?
Because a stockholder po, a stockholder, corporators are the stockholders who are who are the already existing. Ano ba yung exact?
Sige, continue. Kaya mo yan. Nasa ka naman. Sige lang.
Yes, the corporators are the directors or the trustees who were
who's the signatories po.
Okay. Anyway, ito naman, alin ang mauuna? Maging corporator ka, maging director ka, o maging presidente ka?
Corporator.
And then,
Once you become a corporate, or can then be a president and director.
because a president should be a director.
Because
Do you have to become a do you have to be a director when you become a president? Or vice versa? Wait. Muna. Do you have to become a director when you are a president?
No po.
So, pwedeng presidente ka pero hindi ka director?
You cannot be a president po if you are not a director.
So, you have to become a director.
Yes po.
Final answer?
Yes po.
Okay. And then, for corporations which are incorporated before the effectivity of the revised corporation code, what do you need? Do you need to have an approval of the SEC? Diba? What's the default kapag corporation ka incorporated before the effectivity of the RCC? And then, what's the default corporate term? What's your default corporate term pala?
Corporation.
Oh, corporation ka. Tapos, naging corporation ka bago naging effective yung RCC. Right?
Yes po.
Okay, so RCC na, may RCC na. After the effectivity of RCC, what's your default corporate term now?
Sorry, what are you? Hindi ko na po siya na-record.
Okay. Last question. In the book, it was mentioned that a corporation's right to use its corporate name is a property right. As a property, what's the rights? As a property right, what does that entail for the corporation?
As a property right, the corporate name is a property itself po. Hence, as a property right, the corporation has its right to protect its own name and have its secured by patents and prevent other corporation to use its name.
Alright, that was Mr. Mahomo. Thank you. Next person. Mr. Lagota. Are you here?
Yes po, attorney.
Okay, let's talk about the case of okay. Again, can you speak again?
Yes po.
Here po. Okay, let's talk about one of my favorite cases. It's the BPI. You remember the GSIS versus BPI case?
Yes po.
Okay, so discuss to me the facts first.
In the case of BPI Family Bank versus GSIS Family Bank, the BPI Family Bank was was incorporated first, but it existed under a different entity, which is Royal Family Savings Bank. Then, years after its merger with another company which gave birth to BPI Family Bank, GSIS also established its own under the name of GSIS Family Bank. Then BPI filed a complaint seeking that GSIS stop from using the name Family Bank on its corporate name, since it is similar with BPI Family Bank's corporate name.
And then, what's the issue in this case?
Here po, the issue in this case is whether or not there is a similarity between BPI Family Bank and GSIS Family Bank's corporate name. And the court ruled that the court found that there is a similarity between BPI Family Bank and GSIS Family Bank's corporate name, because the court was able to establish that BPI had a prior right to the name, since it was incorporated first under Royal Family Bank, and that the phrase Family Bank would lead to the confusion among the public, since both entities use the same phrase on their names po.
In this case, it was also the Phillips versus CA was mentioned, where the Supreme Court stated the requisites in order to prove that there is a violation of the exclusive use of a corporate name of another entity. So what are these requisites? Do you want me to repeat the question?
Yes po.
Okay. So, in this case, the Supreme Court mentioned in Phillips versus CA, this court ruled that to fall within the prohibition of the law on the right to exclusive use of a corporate name, two requisites must be proven. Namely, what are the two requisites?
The first is the prior right to the use of the name, and the second is
The complainant or the defendant?
the complainant po. The complainant has acquired prior right to use the corporate name, and the second element is
It's about the name. What are
the second.
my God.
The second element is the distinction po. Sorry, I forgot the second element po.
Second element is if the proposed name is either identical, deceptive, confusingly similar, or contrary to existing law. So, last question for you. What will happen if, di ba, for amendments of a corporation, hindi pala ito last question. For amendments of the articles of incorporation, after you voted, di ba, there's voting kanina, we discussed the voting. After the voting, is it official after that, immediately after the voting, and then you ratified it, etc.? Is it already official?
No po, because after the voting, the corporation must submit the amended articles of incorporation the along with the marks which show what parts were amended, and it must be submitted to the SEC for approval.
Okay, thank you, Mr. Lagota. That will do. Next, Mr. Fadriquela, are you here?
Good evening, naman.
Okay, wait lang. Isin ko lang yung game ko. Question. What will happen if, for example, you filed your amendment to the SEC and it's been months and it's still there? Are you gonna wait for a long time before you have the amendment effective?
No, attorney. If the amendment is substantially complied, then it is ministerial for the SEC to issue certification.
Okay, by ministerial, you mean what?
Ministerial means that the SEC will automatically issue. There's no discretion on the part of SEC, but they will automatically issue the requirements, or if the requirements are substantially complied with.
Okay, so for example, today we approved and ratified the amendment of the AOI, and then tomorrow we filed it in the SEC. Is it immediately approved because it's just ministerial?
It will be immediately approved if the requirement is substantially complied by the corporation, attorney.
Okay. So, okay, just to guide the class, it's not automatically approved. Once you file it for the SEC, it's still subject for their approval. That's why there's also submission of the markup, submission of the revised AOI, and then if within 6 months there was no action received from SEC, that's when the amendment will take effect. If you will look at, for those who are not reciting, kindly open your RCC to section 15. Third paragraph. The amendments shall take effect upon their approval by the SEC or from the date of filing with the said commission, if not acted upon within 6 months from the date of filing or from the date of filing with the said commission, if not acted within 6 months from the date of filing for a cause not attributable to the corporation. So, Mr. Fadriquela is somehow correct. It will take effect on the same day of filing, but there's a condition that the commission did not act upon it within 6 months from the filing. And the second requisite is the fault must not be caused by the corporation. It must be it must be for a cause attributable to the SEC, not the corporation. Okay, next question, Mr. Fadriquela. How about those corporations regulated by other government agencies? Example, a bank, if they want to amend their AOI, can they, after the voting, can they directly submit it to the SEC? And then SEC will, is there any other requirement?
The other corporations such as banks are regulated by the Bangko Sentral ng Pilipinas.
Okay, and
therefore, they must file their amended AOI to the Bangko Sentral.
the BSP will approve? Okay. So after the BSP approves the AOI, does it need to be submitted pa to SEC.
Sorry,
Okay, that will do, Mr. Patrick. Thank you. Next, we have Mr. Corbillon.
Yes po, Attorney. Good evening po.
Same question. First, after the approval and ratification of the articles of incorporation, for example, you're a corporation regulated by other government agency like a bank, what will happen? What's the next step?
Attorney, the authorized agency which the corporation attach will issue a certificate of approval with the with such vote that has been made po, Attorney.
Okay, so you submit.
Yes po, Attorney.
You submit it to a regulatory authority supervising corporation.
Yes po, Attorney. The recommendation.
And what will happen if they rejected your submission?
If the submission will be rejected,
And they go to SEC now? Instead of, can I reject ako ni BSP, I'll just go to SEC and have them approve the amendment.
I think they can proceed to SEC, Attorney.
They can proceed?
Yes po.
Okay, I just discussed this part. So this is what happens. Example, you are a bank and then you amended your articles of incorporation. You usually go first to BSP you submit it to BSP to ask for their approval. Not approval, recommendation. It's a recommendation from BSP if they can now proceed with the filing and the submission of the AOI to SEC for approval. Okay? So, attorney, what will happen if BSP will reject my amended AOI? You have to address the concerns found by BSP, by the regulatory authority. Why? Because it's not it's regulated for a reason. For example, for banks, it is subject to public interest. It's highly regulated by BSP because ang daming pera ng mga tao na doon nakasalalay sa mga bangko na yon. And it must be regulated para to make sure na it's well-funded, the protections are there. And if yung amendment mo, lalabag sa law, for example, ang amendment mo, change ng 60-40 ownership ng bank, and required na 60% ownership must be retained with the Filipinos. So you cannot approve that. You cannot proceed in recommending its approval to SEC as BSP. Kasi, it's violation of law, right? For that particular scenario. So, kailangan mo i-revise yun ulit. And then, kapag, example, binalik mo ulit kay SEC, kay BSP for subject for their favorable recommendation and then okay si BSP, nakakuha ka ng favorable recommendation, that's when you go to SEC. Kasi pag pumunta ka sa SEC, na-rejected ka ng BSP, hindi ka natatanggapin. Kasi nakasulat sa law, section 16, AOI or amendment of the AOI shall not be approved by the Commission unless it is accompanied by a favorable recommendation of the appropriate government agency to the effect that such articles of incorporation, such articles or amendment is in accordance with the law. Since specialization ng regulatory authority their favorable recommendation is needed by the SEC in order to approve your submission or your submitted amendment or your submitted AOI or amendment of your A1. Okay, Mr. Corbin, let's continue. You need to close your eyes actually for this recitation. So next question is about still the case of Family Bank. Remember here in this case, GSIS argued that it already included the words thrift and GSIS together with the word Family Bank. So does that help their cause? Or I mean, does it make them entitled to retain the use of the word Family Bank?
No, attorney, the Supreme Court held that even if there is the word thrift or the other word, attorney, it is not sufficient to distinguish that certain corporation, attorney, because they are in the same field of a business, attorney, which is banking corporation, attorney.
Right. How about the use of Family Bank? How was it classified in this case? Is it descriptive, generic, arbitrary, sensitive?
The use of the word Family Bank, the attorney, is generic po, attorney.
Okay, continue.
Yes po, the attorney, as far as I can remember, the use of the word Family Bank here is suggestive, rather, attorney.
Suggestive, okay. And what is its effect to BPI Family Bank? Can BPI insist that they're the only one who can use the word Family Bank?
No, attorney. In that case, attorney, there are two requisites for the prohibited, for the prohibition.
That's also on the part where, so what's the ruling of the Supreme Court? Can GSIS use the word Family Bank too?
No, attorney. The GSIS cannot I cannot use the word Family Bank. Because based on the two prohibition, attorney, which is the prior right and then the confusing, attorney, is confusing. So therefore the BPI can only use the word Family Bank, attorney.
Alright, sige. Thank you, Mr. Corbin.
Okay,
okay, the last one in not yet closed is Mr. Orbigoso. Mr. Orbigoso, are you here?
Yes po, attorney. Good evening po.
Okay, wait lang. Mr. Orbigoso, I will give you a choice. Tama no, Bidel, natawag ko na lahat. Absent si Mr. Alpe at si Ms. Tambago.
Attorney, nandito na po sila. Pati po ako.
I thought you're part of the row of Percy.
Hindi na... Sige po, attorney.
So, saan ka talaga? Are you part of the row of Percy or are you gonna recite?
Recite na lang po, attorney. Last na naman po kasi ako eh.
Oo nga eh. Oo nga, no? Sige. This is what we will do. We still have 4 more. So I will give you a choice to recite tonight or I will call you twice next meeting. So that's the choices, ha? Recite tonight or to be called twice next meeting. But next meeting, you're the first ones to be called naman. So that's the perk naman. Mauuna naman kayong matawag. At the same time, after na matawag ko kayong 4, tatawagin ko kayo ulit randomly. Part na kayo ulit ng ruleta. Ay, ng index cards. So, class, I'll give you the choice. Okay, let's call Miss Tambago. What's your choice? Tonight or next week?
Next week po.
Mr. Alpe, tonight or next week?
I want to recite po tonight, attorney.
Oh naman! Okay, sige. Miss Tambago, you're next week. Okay, next. Mr. Orbigoso, tonight or next week?
And by tonight po.
Okay, Okay, tonight. Okay, next. Miss Soledad. Wala tong deduction. I just wanna give you the choice for tonight kasi it's already 8:30. So, Miss Soledad, this tonight or next week?
Tonight na po, attorney.
Tonight, sige. Hi, let's continue. Hawak ko yun. Okay. I called Mr. Orbigoso. Mr. Orbigoso, you ready na?
Hopefully po. Yes po, attorney.
Okay. So, let's go to the case of... Okay. Have you read the SEC and bank cases?
All of this po, attorney.
Hindi mabot. Okay. Let's just discuss the case of Indian Chamber. Do you still remember this case?
Yes, attorney.
Okay. Sobrang ikling facts. Go.
There is the Indian corporation. They have its name, and then another company po filed application for incorporation having almost identical name. Like, if I recall correctly, Filipino-Indian Commerce of the Philippines. Yeah. That attorney.
And then, what's the issue in this case?
The issue of this case, whether or not the subsequent company who filed the name may attorney in fact I think important fact po, attorney, that I think the Indian corporation po was priorly it ended its term, attorney, and then correct me if I'm wrong, and then another company filed for almost the same name. So the issue here is whether or not if the first corporation that has ended its term, the second corporation can validly acquire the name po.
Okay. So, in this case, has the 3-year period ended?
No, attorney.
So, it has not ended yet. So, how was it possible that somebody registered the name if the 3-year period has not yet lapsed? Okay, Mr. Orbigoso, I will again ask you the question. Do you want to continue the recitation tonight or next week?
I think I'll continue po next week, attorney. Sorry po.
Okay, it's okay. I will not take this against you. Kasi I also wasn't able to come to the class tonight, so it's okay. Thank you, Mr. Orbigoso. I'll call you again next week. Mr. Orbigoso. Miss Tambago, you chose next week, right?
Sorry, nakamute. Yes po, next week.
Next week, Mr. Orbigoso, Miss Tambago, Mr. Alpe.
Yes po, attorney.
Tonight?
Yes po.
Okay, next. Continue with the case of Yan Chamber.
Okay, so for this case, the main
Let's proceed to the ruling in this case.
okay po. So the ruling in this case is that the first corporation who registered their name after the 3 years of expiration of the I'm sorry, attorney, the name was really confusing. So after the expiration of the original corporation, after 3 years, this new corporation filed for their corporation to be recognized by the SEC. So the court ruling here is that the first corporation who filed the name and was duly recognized by the SEC was approved. However, for the second corporation who also applies for their name to be recognized was denied on the grounds that the two-part test, wherein the first qualification, wherein prior rights have already been established and met by the first corporation who have applied and was able to meet. Okay po. And then the second part or the second test wherein if there is deception or the name used was or may cause public confusion is also established here because the second corporation who wants their name to also be recognized by the SEC is very close or has a huge similarity to that of the first corporation po.
Okay. Question. How about the purpose? Do you remember the ruling of the Supreme Court when it comes to the purpose between the two corporations involved in this case?
For the court's ruling in terms of the purpose, attorney, the Supreme Court ruled on the basis that the qualification of meeting the 3 years prior any corporation to apply for their name.
Asking about that. How about the purpose of Corporation A and Corporation B, who both wants the corporate name? So the Supreme mentioned in passing about their purpose and makes it a factor why they decided in favor of one organization rather than the other. So what's the ruling of the Supreme Court about the involving purpose?
Thank you for clarifying, attorney. For the purpose, the Supreme Court find also that the purpose of the two corporations were also similarly the same. The only difference is just the name itself, but the purpose is also similar.
Okay, last question. Have you reached this SEC and bank cases I assigned?
I was not able to go through it, attorney. I'm sorry po.
Okay, sige. That will do, Mr. Alpe. Thank you.
Okay po.
Last but not the least, Miss Soledad. Ikaw na naman yung huli.
Yes po, attorney.
Okay, let's go to the case of the case of Philippine loans. Philippine loan.
In Philippine loans po, attorney, there is a Filipinas pawn shop po who filed a complaint against Philippine loan attorney because Filipinas pawn shop po alleged that Filipinas loan was acting ultra virus or acting beyond its power po, power according to its charter po, because in its articles of incorporation po, attorney, it is a loan incorporation po, attorney, but it acted as a pawn shop po, attorney, which in that sense po, if the Filipinas loan acted ultra vice, attorney, it is a violation po of their charter po, or its article of incorporation. The issue here, attorney, is whether or not the SEC po have a jurisdiction to rule over the issue po or the complaint of Filipinas pawn shop. The Supreme Court po ruled that the SEC po have a jurisdiction over this matter because it is intra-corporate controversy po, attorney. Since it is a issue po or a violation po against its charter, and then the Supreme Court po also stated that over the powers or powers, functions, and duties of SEC attorney, one of its power po is to impose regulatory practices po for the corporations po to act within its charter po or articles of incorporation and the purposes po that is included in the AOI. And then also po, in addition, the Supreme Court po stated that there are two tests po that can be used if SEC po have jurisdiction over the controversy po, attorney. First is the relationship test po, and then second is the nature of controversy test. The relationship test, attorney, it is if the issue po is beyond the stockholders, the members, and so on of the corporation, while the nature of controversy, attorney, this is where it is where the jurisdiction of SEC arose po because the nature of the controversy po, attorney, is the violation po against of its own charter, which the Pilipinas loan po supposed to act as a loan corporation po and not a pawn shop po, attorney.
Okay, let's wait. Next, we go to a question about where, for example, you don't agree with the decision of the SEC with the case. Where do you file your objection? I mean, after the commission, the SEC, where do you go?
It is discussed po, attorney, in one of the cases. The Provident po ata yun. But, in that sense po, you cannot go after the Court of First Instance or the RTC because it is co-equal court. So, the one po that can review the decisions and issuances orders what's not of the SEC po is the Supreme Court, attorney. Or you can appeal po sa Court of Appeals, then next po sa Supreme Court. But you cannot go po to the Court of First Instance or RTC because they are co-equal po, attorney.
Okay, so if you are gonna appeal to the Court of Appeals, how many days do you have?
15 days po upon the SEC po should act po on appeals po, awards, judgment within 15 days po, attorney.
Okay, after the CA, where do you go?
The Supreme Court po, attorney.
Immediately, you don't file MR?
You can file motion for reconsideration po sa Court of Appeals po, attorney.
Before you go to the SC?
Apo. Exhaust all the po muna.
The remedies. The administrative remedies first, and then the remedies available sa court. Okay, thank you, Ms. Soledad.
Thank you po.
Okay, so we still have, that's all for tonight, class. Finally, makakauwi na din ako. I'm really sorry for not being able to come to class on-site today. Mga 4 o'clock, mga 3 o'clock talaga. We're supposed to have the meeting at 2. Tapos, na-extend ng 3. Maya-maya 4 o'clock na hindi pa nagsisimula yung meeting. Pero we were all there na for another concern. But when I realized na it's already 4 o'clock, I reached out agad kay Bidel to tell everybody to have an online class instead. Kasi I don't wanna miss a class. Wala tayong extra week. Bidel, can you compute pala? Kung yung, di ba, nilagyan ko ng week 1, week 2, week 3. Can you put dates on those weeks? Para your classmates would know. Example, meron silang work travel or personal travel, and then kung ano yung tatamaan nilang week. And also, para din matansya natin if alin yung tatamaan bago mag-midterms and bago mag-finals. And then, if may leeway ba tayo na extra week before we take para example, we need to party or I can give you a rest day. A rest day. If ever kaya nating mag-rest day. If may extra date tayo, why not? But kindly check. It's not urgent. Just let me know once the dates are available. And please also put into consideration your schedule during the bar exams period. So, mukhang walang pasok nun. Just assume na wala tayong klase on that Friday before the bar. I will not have, during the bar. During the bar period. The Friday ng bar period, wala tayong class. Kasi everybody's assisting for the bar ops. I will assume everybody's assisting. But if you're not, I will not take it against you. But for those who will help, I will give you an incentive. So, ayun lang. See you next week, class. Before we end the meeting, the scope for next week is already available in your syllabus. It's named Week 3. So, the rest of the cases, the rest of the topics that was not covered tonight, that was not asked in the recitation tonight, I will just assume that you've read it, you've studied it. So we'll proceed to the next one. I just highlighted the portions na nakakalito or portions na kailangan kong i-emphasize sa inyo kasi possible yun na lumabas sa mga exams. And class, bantayan nyo yung lalabas na questions ng corporation laws sa bar. It might be asked in your finals exam. And just try. Baka malay nyo, kaya nyo nang sagutan yung corporation law part ng bar. Kasi karamihan naman sa mga since sa inyo, fresh pa yung corporation law. Wow, fresh. May natututunan sana kayo, no? So, dahil karamihan sa inyo, inaaral natin ngayon yung corporation law per se. Mas malapit or mas naaalala nyo pa yung mga portions compared sa mga nagbabar na sobrang dami na nang inaaral right now. So, by now, I hope pag nakita nyo yung question sa bar, ma-inspire kayo na, uy, may natututunan ako, or, oh my God, kailangan ko pang mag-aral kasi wala pa akong alam. So, it's a wake-up call or a celebration. So, yun lang. Class, I'll see you next meeting. We'll discuss week 3. Bye. Good night.
Ingat po, Thank you po.